Hi, everyone. Good evening. Carl Steinbeck here, ready to talk about a few things that happened today in the Florida versus Donna Adelson case. Here in Tallahassee, we had quite a day with a couple of attorneys testifying this morning, two board certified attorneys from Tallahassee. One was Wendy's attorney, and the other one was what was also a friend of Wendy's attorney, another female attorney. So we're going to talk about those two attorneys today. Also, what Donna had to do today in terms of whether she's going to testify or not. So she decides to not testify after some long delays and indecisive behavior by both her and her lawyer. So it was really a crazy day. Some things I've never seen before in any court of law happened here today. So let's jump right to it here. I don't have time to cover all of the things that went on because we could be here for several hours covering the attorney's testimony. So what I'll do is I'll jump right to the part we have here where the cross-examination of Wendy's attorney is done here. So let's jump right to that, and I'll jump in and make different comments for y'all. Okay, I'm hearing some back feed. Stand by. One second here. I'm on a different mouse here. We're at John's Airstream. John set up this little studio for us. John's been here the whole trial since after the jury was selected. All right, going to go ahead and play here.
Morning.
Good morning.
So you said you weren't aware of Donna Adelson's involvement.
She was not involved with me.
Okay.
So no.
Did you know that she was drafting Wendy's filings and having Wendy copy and paste them to send to you?
She couldn't have drafted any of the filings because I drafted the filings.
What she would like to be put in the filings? How about that?
I'm not aware of any of that, no.
Okay. Do you know that she was drafting things for Wendy to put in her filings in Wendy's voice?
Not that I'm aware of.
Okay. Did Wendy, though, give you input on things maybe to put in filings or things that she would like said on her behalf?
Not a lot. I talked to Wendy on a pretty regular basis when I was filing something on the phone or by email. And she was a very good client, in all honesty, where she listened to me and she basically, we have clients that don't. Now we have clients that give you ChatGPT and want you to do ChatGPT, please, so there's that. She wasn't that client.
Okay, so what I want to clarify here is that what is required in state bars across the United States is if you are called to testify on behalf of a client, you still have a duty of loyalty to that client. And so for her to be able to testify here, this is Wendy's client, Wendy's attorney, excuse me. And so Wendy would have had to sign a disclosure and waiver of attorney-client privilege. Otherwise, she just can't get up there and start talking about what her and Wendy discussed. So what we have here is her making a positive comment about Wendy and that she was a good client, but she also sort of mentioned a comment that she always talked to Wendy before she filed something, but she also had talked about how this is sort of a normal file. It's not too contentious between the parties. It's not a big deal. Try to downplay the bad blood that was going on with Wendy and her efforts to circumvent things that they had agreed to in the divorce decree regarding the children and how they would co-parent the two children during their separate times. So keep in mind, this attorney cannot say anything bad about Wendy. She could even think something bad about Wendy, but she cannot say anything bad about Wendy unless it's directly asked and There's no way to sort of squirm around it or twist around, but she still has that duty of advocacy on behalf of Wendy's interests, even though she's no longer representing Wendy, even though the thing's been done for years and years now. So that's the context and light you got to keep in mind when she's testifying. It's if she never left Wendy as a representative attorney for her. So once you take that into context and understand, she's still advocating for Wendy. So even though she's saying things here that you may think are just like, well, she can say anything good or bad about Wendy. It's like, no, she really cannot say a whole lot of anything bad about Wendy. And so the prosecution did not bring that out on either one of these two attorneys. But let's see here where this goes.
She would say something like, well, and my pleadings were very short. I mean, my pleadings were very, very short. They were to the point and like, no, dismiss this. That's not true. There wasn't a lot more going on in most of them.
So you wouldn't have knowledge of Wendy sending pleadings to her mom and saying, let's edit this?
No, because I wouldn't have edited it based on that anyway.
Okay.
I mean, maybe they did, but I didn't do it.
All right.
And I never heard about it.
Okay. So this would have been between Donna and Wendy.
If that happened, yeah.
But she's even making it sound like you don't ever get stuff from clients back that's been edited, word changes, suggested paragraph revisions, things of that nature. After all, your client here is an attorney, so you're telling me they have no ability to edit things or clarify or correct things. So this seems to be some spin here in and of itself.
Mentioned that, of course, she had a shot with relocation, but given the situation in case being
okay, right there, for her to say she had a shot at relocation, what she says here in this trial is different than what she said in Charlie's trial. In Charlie's trial, she made it sound like, well, it was like a really long shot. It was like something that wasn't expected to come forward and be successful for Wendy. So she says this differently now in this trial. Now she's saying she's got a shot at it. And guess what? In any state in America, unless there's a material change of circumstances of something that could not have been contemplated or foreseen among the parties when they do a divorce settlement, that's the only reason they'll reopen a divorce decree and deal with revisiting either things about assets or things involving the children and custody determinations for that. So I think right here, her saying she had a shot, what was a material change of circumstance, attorney, that would allow this to be reopened? What was the material change of circumstance? What, that Wendy was not happy in Tallahassee? That Wendy didn't have a job that was full-time guaranteed tenureship? All that was known ahead of time. What, that her parents were in Florida along with Charlie? All that was known. So this motion, I'm not licensed here in Florida, but I can tell you this motion in any of the 4 states I'm licensed in, this would be completely bounced out of court. Okay. And that's exactly what happened in this case. The judge heard this for Wendy a few minutes on the stand, talk about why she wanted to go relocate to Florida. And the judge was basically like, what, this is not abuse issue you're trying to reopen this case by. So she shut it down, and they didn't even get past more than 10 minutes is what my understanding of Wendy testifying about why she wanted to reopen the divorce decree that she'd actually signed to and settled to a year prior.
The kids were raised in Tallahassee, the parents' jobs with FSU. You were not personally surprised when the relocation was denied?
I'm never surprised when a relocation is denied.
Because it's hard to prove detriment at that time.
I'm always hopeful.
She said, I remember she said like maybe once she's had a successful one. Wendy's was completely worthless from the facts. She had no facts in her advantage. And so if you have no facts in your advantage, will an attorney take it because they want to keep their practice going? They can make money, and you can make a pitch of. Maybe you'll be the 1 in a million chance that'll something will win favor for your client. But there's no facts here that justify something that wasn't contemplated and wasn't material, that wasn't known at the time they signed and settled their divorce decree.
You know, but
right.
And I thought she had a good shot. I wouldn't have let her do it. I mean, I'm not going to file a frivolous motion. I thought she had a good shot for no.
That's not what she says the last time, folks. I wish I could have the time to pull her previous testimony when testified in Charlie's trial. Pretty good shot at this, really? So what I would have drilled down is, what is the material change of circumstances here, counselor?
Number of reasons.
Regardless, though, of what you think, do you ever have clients or family members of clients who have unrealistic expectations of what the courts will allow or what you can do for them?
Yes.
Okay, even given your best guidance.
Yes.
Okay, that's not an uncommon thing.
No, that's why parents are often involved in these cases to talk to me about what they think I should be doing. Yes, I get that a lot.
Right, and at that relocation hearing, were Donna and Harvey Adelson possible witnesses?
You know, probably why I had them sit outside is because they
Right.
could potentially be witnesses and invoking the rule. However, I think
You didn't look up the file to determine if indeed you'd had list them as witnesses. You would have had them listed as witnesses. So that's a very simple thing to look up in your file. You could also look at the court file at the courthouse, and you've known for months you've been on this witness list.
I think we had come to either the close of our case.
But you wouldn't know that until
Right.
you were done calling
Correct.
witnesses.
So that's right. Yeah.
Okay, so that's why they were in the hallway.
That's why
most
they were in the
likely.
hallway.
Yeah,
Okay.
because the judge shut you down, Wendy. They shut you down before you could even finish your direct examination through this attorney Aberson. The judge shut it down because she thought it was frivolous. Okay. A judge only shuts the case down when you're in that short a time window, 10 minutes, when the judge that frivolous. Okay.
Okay, not because they didn't care or they weren't involved.
Oh no, they were very nice. I mean, I met them.
You're very
They were
nice.
there when I got
What's
there.
that got to do with the question here? So she's still in the advocacy mode for Wendy and her interests, which include her family interests, which includes Donna's interests. So this is an Adelson lawyer.
They introduced themselves. They were very nice. We did our thing. Came back and told them afterwards. Nobody yelled or screamed or cried or did any carrying on, which sometimes happens. So no, it was all very appropriate.
Okay.
You can remember that, but you can't remember if they were witnesses. That's an interesting thing there.
Do you sometimes have clients or family members of clients who take the news harder than you do when they lose something in court?
I don't like to lose either. So there's that. I don't like it. That's why I don't like to go to court if I think I'm going to lose. That's why I want to settle things. But
Oh, okay. So why would you take Wendy's case? You got basically thrown out of the courtroom there.
sometimes
I wish you would have asked, how long did Wendy testify for before the judge shut this down? You never got to cross-examination by Daniel's attorneys, Danny Markel's attorneys. That's how this thing was a joke.
they take it really hard, especially family if they're not there. And they do.
Okay. And you said Wendy was upset when she was denied the relocation, but she was calm. Oh, let me also ask you this. Wendy Adelson stipulated to the denial of the relocation after you found out behind the scenes from the judge that it was going to be denied.
Correct.
Okay. And she was upset about it, but calm.
Yes.
She's not screaming.
No.
Okay.
So the judge was not going to take this nonsense because it was frivolous. So if it's frivolous, the judge's not going to agree. Okay, what are you going to do? Still fight it if the judge says we're not going to hear it? So it was basically a forced stipulation because of its frivolousness is the way I look at it.
And I have people do that. I mean, I've had to have my own clients taken by the bailiff out.
I'm sure you've seen it all. And how did Donna Adelson feel about not winning the relocation?
I don't know how she felt. I can only tell you that Wendy, and then briefly, as far as I remember, because I mean, it was 13 years ago, I think I talked to all of them and kind of told them what happened, what was going on. And, you know, I didn't agree with the judge, but this is the judge and they get to make the decisions. And I think that Wendy went and talked to her parents without me and then came back and said, okay, we're good. We can go into court and we can stipulate.
Okay.
Which is what I had suggested.
So if there are emails of Donna Adelson being upset about and very disappointed and about it being denied or unhappy with your representation for some reason, that's not something she's telling you to your face.
No.
Okay. You talked about Dan Markel not paying what he was supposed to pay according to the settlement agreement. In Dan Markel's court filings, did he give, and I know you don't agree with those reasons, but did he give his reasons for not paying?
He gave his reasons.
Okay.
Yes.
And that included the fact that he was accusing Wendy of noncompliance.
That's true.
Okay. Eventually, did you seek to have Dan Markel held in contempt of court?
I did. It was part of my motion, was to have him held in contempt of court and enforced it. That's not the kind of contempt where I can throw him in jail.
Yeah, what does that mean, contempt of court? Can you explain that?
So in a child support hearing or an alimony support hearing, if someone doesn't pay their child support or their alimony, we can have someone held in contempt of court and put in jail if we can prove they had the ability to pay, but they're just not paid. And then the court can put them in jail until they pay the amount they're supposed to pay, okay, because they have it. If it's a property issue, we can't really have them held in contempt of court because it's a property issue. And that was part of why Dan's pleadings didn't make a lot of sense, because he was mixing up property and child issues, and you can't do that. It's strictly property or it's kid issues. In a property issue, it would be a multi-step thing to have him held in contempt of court. He would basically, the judge would have to find that he was not paying, he's willfully not paying. And then,
could I ask you a different question?
Okay.
Yeah, but what she's splitting the hairs on is that Dan was also talking about child issues, the way he was being treated, the way the boys were talked to by Donna, possibly in front of Wendy, about that your dad is stupid and trying to keep the sunshines of mine away from me, meaning you two boys. So if it's all rolled into one motion, then there is some stuff that has to do with property, and there's some stuff to do with the custody arrangement not being complied with. So the title would have something to do with motion to hold in contempt or show cause why they should not be held in contempt. And then you have the other two issues below it. That's just the title. So the title can encompass something that covers more than just the custody aspect of it. So that's why I think this is not really a straight answer here. It's misleading.
But even in a property situation, the court could put him in jail ultimately, but it would be multiple steps I would have to go through. It wouldn't be just one step. It would be difficult.
Okay, so maybe it's depending what the property situation is. Ultimately, if you violate an order of the court, anybody could be found in contempt. I mean, we've had the judge mention contempt today just because Donna was not giving an answer on whether she was going to testify or not.
What ultimately is the consequence of that is my question.
So ultimately, the ultimate consequences, we would probably get a final judgment against him for the amount that was owed.
Like a lien.
And a lien against, and we would get a lien against the house, and and I have to do this often, I would send them to a debt collector attorney who would then have to file another suit to be able to collect that money. And then they would probably be able to go into his assets and get the assets. So it's a multiple stage process, which is why I just wanted him to pay the money and not make me do this.
So if it was successful, probably a lien. Worst case scenario, he could go to jail. And then him being an attorney, though, could he lose his bar license possibly if he's held in contempt of court, or at least be in trouble with the bar?
He could. I've had lawyers held in contempt of court over these issues before. I haven't had one lose their license yet.
Okay.
But they could. It is a possibility.
Did you inform Wendy Adelson that you were seeking to have him held in contempt?
Yeah.
Right there, that goes to show you that his motion to hold Wendy in contempt, it is a possibility that she could be at a minimum in trouble with the state bar and possibly lose her license. It all depends what the facts are, and it's very fact specific. So this goes to show you there was something that Wendy would have absolutely feared by Dan mentioning is that she's not showing that she's qualified to continue teaching students, and that she is also has these ethical issues of concern by the way she's responding in these divorce proceedings and subsequent reopening efforts that Wendy made on the relocation, and that also Dan made to hold her accountable for asset avoidance on the affidavit that was filed early in the divorce proceedings. And so this thing was looking like it was getting ugly, and Dan was wanting to make sure justice happened because he was not getting a fair shake by Wendy.
I'm pretty sure I probably did, because it's kind of a generalized form. It's a motion for contempt and enforcement.
Okay. And then at some point, did he allege that Wendy Adelson should be held in contempt?
I don't know if contempt, I can't remember if he actually said she should be held in contempt legally the way that I was using it. I think his pleadings were much more, Wendy should be disbarred.
Okay.
Wow, so that's even more serious. Wendy should be disbarred. So there you go. That's what I've been saying. Wendy had this fear that she could lose her job and get disbarred. Okay. That's why plan B, when the judge shut down the relocation, it's like, oh, okay, we tried. And Operation Plan B was
That's what he specifically said.
Right.
She was committing fraud and she should be disbarred.
Would you describe this divorce as contentious?
I wouldn't describe the divorce as particularly contentious at all compared to most of the divorces I had. I mean, we settled it. I don't settle a lot of.
So how many of your divorces that you handle have attorneys involved, where one of the attorneys says the conduct of the opposing party spouse is so bad that their job should be on the line and they should be in trouble at the state bar? I mean, this is not a common thing. So for her to downplay this as not being contentious, I just don't see that's credible at all.
My cases where we actually go to week-long trials over things of that nature. I think it was like any divorce where there were ups and downs of moments where it was contentious and not fun. But for the most part, we kind of settled it. We settled it after mediation and it wasn't a problem. I do think that this whole issue of the enforcement.
Okay, the mediation, she's not distinguishing between the mediation that happened in 2013 that allowed them to settle their divorce versus what was happening right before Dan got murdered, which was they had a hearing pending and some depositions that were going to be happening about Wendy's behavior in the filings of the divorce decree, and also the issues involving her and Donna acting inappropriate around the children.
Got a little contentious. I really didn't understand it because he paid the first $50,000 fine, and then all of a sudden he decided not to pay the rest, and I didn't really get it and know why he was doing that, because the parenting stuff didn't come up for like several months afterwards. So none of what he was doing made sense. I think he just got upset with Wendy or something. I don't know what it was.
Okay, thank you for that information. It wasn't contentious, but you did say that his motions were very personal. His pleadings were very personal.
That's where I think it became contentious, is when he did that.
Was that personal attacks on both Wendy Adelson and you?
Correct.
And he was alleging that Wendy Adelson committed fraud, right?
Yes.
He's alleging you committed fraud.
Okay.
It got so bad that you had to get off the case so that you could be a witness on Wendy Adelson's behalf, right?
Correct.
Knockdown drag.
That's happened before, though. I mean, I've had that happen before.
And he alleged Wendy.
Yeah, but was an attorney saying that you were committing misconduct? An attorney, not some opposing party's client that's saying that about you. An actual attorney who's highly esteemed attorney at FSU Law School. That's a totally different thing here. She, in my opinion, definitely has an axe to grind against Danny Markell, because that is something that she would have been highly offended on. And now's her chance to score points back at Dan. And this is her moment that Dan can't defend himself. So she can try to say whatever she wants. But the court proceedings and the filings thereof, they definitely show this thing was contentious. And this lawyer was mad at Danny, and also Wendy was mad, highly angered, because she could have lost everything there because Danny was calling her out on her misconduct. So that's what this is. That's why this thing was gearing up for the Plan B operation to kick in. When the courts failed, there's got to be another way to go about it.
Should be disbarred, you said.
Correct.
And he's having issues with Wendy's mom, Donna Adelson, even being able to watch the kids, is what you said in one pleading.
One of the pleadings said something about the right of first refusal that he had, and she shouldn't be allowed to have the kids unsupervised, I think, during right of first refusal, because she was saying things about him to the kids, he thought.
And did the litigation between Dan Markell and Wendy Adelson continue even after you got off the case?
Once I got off the case, it was the end of June, and I think that he was gone within a few weeks after that.
So
How interesting. You mentioned disbarment. A couple weeks later, you're wiped out. You're murdered in your garage, and you never have to face any of these legal issues again. They're forever expired.
So you were supposed to be a witness on Wendy Adelson's behalf, right?
Correct.
Were you ever able to have that hearing?
No,
Why not?
because I got a call from Jimmy Jenkins when I was in Tampa and something that he was done. It was pretty shocking.
Does that
Well, why don't you say the word murdered? Why can't you just come out and say it? That he's dead? Shocking news. You don't say it's horrible news. You just say it's shocking.
happen very often in your divorces?
That does not, we've had a few people get murdered and I've had a few suicides, but it's rare and I remember all of them.
Right, but not contentious.
Sometimes, I don't know with the suicides, I don't know.
That's all.
Thank you.
Further examination. Briefly, Your Honor.
Oh, brother. So this guy, gentleman, very painful to listen to.
You may.
He's very disorganized, and it's so many detailed questions. And basically what they did is they tried to make Dan look like he was a deal. They're trying to bring out how Dan's looking bad, and he was filing frivolous stuff. He wasn't a family law attorney, so he was making it personal, putting things in the wrong context, the wrong legal format, and filing descriptions, and just made it look like he was writing the motions and not his attorney. But he did have an attorney involved in that. So these are signed off and blessed and signed by his actual attorney on the case. So
I'm going to approach and show you. I'm sorry. States demonstrative A, I think it's court 1, page 441 of the demonstrative.
Bill and Ruth Markell.
And then total 454.
Sure. Okay.
Is that the March 26, 2014 pleading that Mr. Markell filed?
It appears to be.
Can you turn to 454 that I had tabbed?
Yes.
Is that the prayer for relief for that motion?
Yes.
Can you direct your attention to the portion that reflects my client's, Donna Adelson's time with the children? Does that reflect that Mr. Markell was asking that my client's unsupervised time with the children not interfere with his right of first refusal?
I think you're talking about paragraph 6, where it says, enjoin the former wife from allowing the maternal grandmother to have unsupervised time with the children consistent with the right of first refusal. That was that right of first refusal.
Yes.
And to impose appropriate limitations to safeguard the children from being subjected to disparaging comments about their father.
Ms. Adelson, did you testify that the divorce was not contentious, but some of his pleadings post-divorce were contentious?
I think that's accurate.
And that his pleadings were personal. He essentially he attacked both Wendy Adelson and yourself.
Correct.
Is that what caused you to withdraw?
I'm very used to personal attacks. I've had a lot of personal attacks. The only reason, and I'm fine with that. The only reason.
So you're basically saying that Dan attacked Wendy, now he attacked you, and this is an effort by the defense to make it look like what? That this was escalating to the point that the Adelsons had to do something. So I don't know what you're getting here, counsel, but you're digging a hole for your client by making it look like they had even more motive than what the prosecution brought out on cross and brought out in their case in chief for Donna to take part in this murder.
The reason that I withdrew is because I was going to be a witness, not because I cared what he said about me.
Had Mr. Markell not included in his pleadings these attacks, would that hearing have gone forward in May of 2014?
If he had not included personal attacks against me that I would have had to testify about, then I would have continued with the hearing.
Now, I want to go back to relocation. After the relocation hearing, my client, Donna Adelson, appeared to accept the court's ruling to you.
As far as I know,
You don't know what she said privately, do you?
I do not.
All right, so I'm going to go ahead and stop it there. So that is Wendy's attorney, Kristen Abramson. So now let's go ahead and go to this other attorney, Linda Bailey. And she was brought in as an expert. So trying to have something that's more neutral and that wasn't in the actual litigation trenches here. Stand by. Screen is not presenting for some reason. Stand by. Yeah, Georgia, she brought out some good points with this Linda Bailey. There we go. Yeah, so it was basically something you don't want to see on a defense case on a murder charge, as you bashing the victim. Like, so this is what they did though. So it was really much disgusting to see, and a lot of people were upset. I think people in the jury had been also disgusted by this. So we arrived here late morning, and so we got to see some of this en route from Texas, and now we saw some more of this today and talked to folks. So yeah, this was not a good day for the defense at all by bringing these two witnesses. So let's see what this cross-examination on this so-called expert.
Cross-exam.
What is it you were asked to do in this case?
I was asked to review the documents I was given and to opine about whether this was truly a highly contentious custody case, essentially.
Yes, they were there.
And why would your opinion about whether it was a highly contentious custody case matter?
Well, that's for somebody else to decide. I mean, I've done 2,000 cases or give or take 100 on each side, and I think I have a pretty good judge of where this falls as far as contentiousness.
Sure, but you're somebody that has vast experience with a ton of divorces, right?
Sure.
The parties only
So she was trying to make this out on earlier direct examination. This wasn't that contentious. It wasn't a big deal. And so there's really no motive to have Dan killed and murdered. It's just like a routine type of divorce, right? So Georgia's going to go after her here.
have experience with one divorce, right?
I don't know how many they have experience with,
So
but
isn't
sure.
the contentiousness in the eye of the beholder, in the sense that to you it might not seem like a big deal,
Hmm.
but to the parties it might be the most important thing in the whole wide world. Do you
Well, that's
agree
one
with
reason-
that? Do you agree with
Ms.
that?
Kappelman, Ms. Bailey, wait for the question, wait for the answer. Do not speak over each other.
Do you agree that a case as a lawyer might be routine, whereas to the parties it's the most important thing in the world?
To some degree, that's one reason I called Kristen. Ms. Adamson, in particular, of the lawyers in our community of the family law bar, is extremely measured and calm. And I find that when I litigate against her, we reach resolutions, that people stay measured and calm, and we get things done. She's not one of the other lawyers in town who may stir cases up or play on those emotions. So our job as lawyers.
Yeah, but you know what's going on behind the scenes down in Miami there with Donna? You have no clue. And you're able to keep things calm emotionally wise. Where do you have that kind of ability to know what's going on in the personal lives of your clients and their extended family members? You don't.
Is to explain to our clients when we get emotion. If I get something, for example, that, although I've never had something similar to what Mr. Merkel would file, the immediate response is to call your client and go, I know you're going to read this at first glance, so it's going to seem messy. But there's no legal basis for this, so don't worry. And my understanding is that is what she communicated to ID.
Okay. Well, there you go. So she's just backing up what she testified to on direct. And oh, by the way, this attorney got to sit through the testimony of this other attorney when she's not supposed to. And she claims she thought she had permission to do so when she never had direct permission from the judge. So the defense botched that, or what happened here? You know, as an attorney, you should be sequestered, not listening to other people's testimony. So let me back that up here.
Is to call your client and go, I know you're going to read this at first glance, so it's going to seem messy. But there's no legal basis for this, so don't worry. And my understanding is that is what she communicated to ID.
Okay. Well, if Kristen Abramson told that to Wendy, who's to say that Wendy didn't say, no, my attorney says this is bad. Mom, this is really bad. This has turned out bad. Are you going to do something about Danny doing this to me? I'm going to lose my job. I'm going to be up here having to pay rent with no attorney income because my bar license is on the line. What's going on down there for you guys taking so long to get this problem taken care of? So that's nothing that this attorney can have any firsthand knowledge of.
And when you communicate these things to your clients, hey, this is no big deal, this is no problem, this is a bunch of gibberish, do they always accept that?
That's not the way I would present it, but
Do they ever get upset about the gibberish in the pleadings, the offensive materials in the pleadings, regardless of whether or not it's going to impact their chance of success in court? It can be emotionally charged, can it?
I would say annoying more than emotionally charged.
You would not say that divorce and child custody issues are emotionally charged?
They can be, but in this
And-
case, they weren't.
They weren't? How do you
Oh
know?
my gosh.
From the pleadings, because I'm
Right there for the defense to call this person. She completely embarrassed herself. This is really cringy here to see this. So keep going, Georgia. The jury can just see this for what this is. She's a hired gun for the defense, lost credibility in front of the jury on this, is probably friends with this Abramson attorney. As you saw, they have a lot of cases they work out together, and they don't have much fights going on because they're buds. That's one of the main reasons they don't have contentious knockdown, drag out litigations, because they're buds and they'll get their clients on board with not having fighting going on. But that's not to say fighting's going on behind the scenes and that hatred is going on that remains unknown to them. They don't have no idea what's going on behind the scenes with their client.
I don't have 10,000
you're
pages in
not-
front of me.
You're not in the mind of the people whose lives are impacted by these pleadings. It's not just about pieces of paper and a binder, is it?
That's what she said it is. So yes, Georgia, that's how ridiculous this defense witness is. Glad you pointed that out. She knows exactly how mad Donna got over this. She knows exactly how upset Wendy was over this, right? People she never even met. She knows exactly what they were thinking. I mean, this is just mind-boggling.
I don't think that's what I said.
People's lives are impacted by the decisions that go on in court, which for you are routine. Would you agree?
In this instance, they reached agreement on all issues, so they had complete control of what was coming out of the court.
Ma'am, could you please answer my question?
She's doing just like what we had initially from the other attorney testifying, which is they're not separating from what happened in 2013, and then there was a settlement, and then the subsequent issues that happened in 2014 that led to motions for contempt filed by both parties. So it just looks very, very much misleading here.
Are people's lives impacted in drastic ways by routine matters that we see in court as lawyers?
People's lives change after divorce, certainly.
So, like, I may think I've got a bag of stinky garbage, but the garbage man might not think it's stinky at all. Do you get the reference?
I don't.
What is no big deal to us is a big deal to these litigants, right? You can't agree with that.
Perhaps.
You can't agree with it. Strike the question.
Yeah.
You were asked, let me ask you this. Let's go on to something else.
Yeah, the jury trusts Georgia. Georgia's frustrated with another attorney acting this way and making this ridiculous assertion that she can tell from the pleadings that it wasn't contentious. So if it's not contentious, you're talking about also the mannerisms and behaviors and effects of these filings on the litigants. That's what's really defense is trying to have you call for to testify, and you can't. You have no personal knowledge, and you're absolutely guessing. And what about the fact that Dan Markell was talking about losing your license, both Wendy and her attorney, for their behavior? So it's really just an outrage.
Have you ever had people get murdered or commit suicide based on the issues that are going on in your family law
I've never had
litigation?
anyone murdered. I had in one instance, a Middle Eastern person committed suicide just because there was a divorce, and that was shameful. So nothing was it was literally the day after the petition was filed, and he had threatened, if you file, I'm going to kill myself, and indeed he did.
And to you, divorce is not shameful, is it?
To me, divorce is not shameful.
Divorce is not a basis to commit suicide, is it?
Not according to me, but I didn't grow up in Iran or wherever this custom or feeling.
Exactly, Ms. Bailey. To
Correct.
that person, it was a reason to commit suicide, right?
Apparently so.
Aren't these issues raised in these pleadings
Yeah, that's, I don't know how much.
potential fuel to make people upset?
Potential fuel to possibly make people upset.
Yes, ma'am. For example, you were asked about what we've called the grandma motion. You say, oh, it's no big deal. It wouldn't be granted. It was buried in there. But the allegation is grandma is disparaging me to these kids, and I won't tolerate it, right? Couldn't that be upsetting to grandma?
You'd have to ask grandma. I don't
Exactly.
Oh, okay. You don't know whether
It
it's
should have
contentious
been.
or not.
There was no proof.
No proof because you don't know what's going on in these people's lives and how much they hated Dan Markell. So that's what's really going on here. So Georgia is completely destroying you as a witness. Your so-called expertise is not coming forward for defense. You're actually helping the prosecution here.
It shouldn't have been, in your opinion.
In my opinion.
But in your opinion, divorce is no reason to commit suicide, right?
True.
Gibbers, according to the evidence in this case, means Jew in boots. It's not a flattering term by that definition or by your definition of someone that speaks gibberish. Can we agree it's not a flattering term?
No, it's probably not flattering, but I've seen far, far worse.
You've seen worse.
I have.
Really?
If Mr. Markell wasn't paying by the deadline, isn't that something that would be potentially upsetting to the parties or their family members?
I don't know how upsetting $80,000 would be. I don't know.
$80,000 is a lot of money, isn't it, Miss Bailey?
It depends on who you are.
Exactly. So we'd have to ask the parties, right? Right?
Sure.
Okay.
Yeah, you're not an advocate here to speak on behalf of what was going on in the Adelsons, people you never met.
Yeah, I think on that issue, he clearly had the asset. So at the end of the day, he was going to pay. It was just a matter of jumping through hoops to get the money.
He was either going to pay, or he was going to get sanctioned by the court, or he was going to end up in jail, right?
I don't see any possibility he was going to end up in jail.
Okay, well, you sat in the courtroom during Ms. Adamson's testimony,
I did.
didn't you? And Ms.
did.
Adamson said that that was one alternative, an extreme alternative, obviously, but that's what contempt means, right?
But that
Ultimately.
Wouldn't even come into play until the motion for enforcement, and then he didn't abide by that, and then the judge asked him to do something else, and then he didn't abide by that. But I think jail was pretty far-fetched.
Well, as long as he pays. Ultimately, the teeth is Adamson was incorrect on that point, I guess.
Objection or that question was strike.
I'll rephrase it.
Was the objection again?
It's an improper comment on the witness's testimony.
Please rephrase the question.
I said Ms. Adamson was incorrect on that point when she said jail was a potential option. Is that correct?
Well, I could break it down. There's two different matters in that financial motion on October 31st. One was the $70,000 still due to Wendy. Jail is not a possibility, but you don't send people to jail for failure to pay money. We don't do that. The $10,000 in fees to Kristen was more debatable because that could have been in the specter of support. And if you don't pay alimony or child support after repeated chances, I guess you could say, jail might be an option, but there's always a purge to that. So I've seen many times in child support, if you don't pay child support, then the judge says, bailiff, get, Mr. So-and-so or whatever. And then all of a sudden he comes up with money out of his pocket to jail. So you always have the key to the jail when you owe a support obligation. So technically, if he wanted to go to jail rather than pay Kristen the $10,000, eventually there may have been a hearing where that happened. I've seen one person in my career go to jail over child support.
Right, because they pay because they don't want to go to jail. If there was no jail and no consequences, they would never pay, right?
Some people wouldn't.
Yeah, because you don't represent poor clients because you have such high retainer fees. So people with money come to you. So no, they could pay it instead of going to jail for non-payment. So how much pro bono work do you do for folks that are deadbeat supporters of their children?
And that's just support. There's no jail consequence to the $70,000 to Wendy. There was only the $10,000 to Kristen that could have possibly remotely been a possibility.
Did you see evidence in this case of Wendy taking her mother's suggestions, cutting and pasting them into an email as her own, and then forwarding those questions to Ms. Adamson?
No, I didn't see any.
And did you see in your review of the evidence in this case, Ms. Adamson responding to those questions and Wendy then forwarding those answers to her mother?
I don't recall that. I don't recall seeing that.
Did you review the communications from Donna Adelson, both in the form of email and text messages, that suggest that she was in fact extremely disappointed and upset about the outcome of the relocation motion?
I did, and probably the 5 days after the relocation, which was, say, 4 weeks before the ultimate settlement in July, there were a flurry of emails where she was obviously upset.
Did you review Mrs. Adelson's communications after July 31st that suggest she's consistently still upset about this?
I wasn't provided.
So you were, I'm sorry, finish your answer. You weren't provided any?
I wasn't provided after the flurry, right after the relocation, before the final judgment was entered in July of 2013. After July 2013, I don't recall seeing any emails from Miss Donna Adelson about relocation.
Did you see any emails from her at all post settlement?
Not until maybe December. It was a while. October maybe.
Okay.
Several months.
If Dan Markel had agreed to the relocation post denial, post stipulation, post, it could still happen, right? I mean, if he agrees, it could happen.
Sure, if he agreed, she could have relocated.
All right. And if he was murdered, it could happen, right?
Well, obviously.
So you categorized Dan Markel's pleadings in a lot of different ways: baseless, untrue, unenforceable, gibberish, nonsense, suggestion of unethical filings on the part of his lawyer to sign off on them. Are you saying, I think what you're saying is that those things wouldn't amount to much in court because there's not really effective filings. Is that what you're saying?
What I'm saying is his motions post July 31st were not based in the law. And I don't think that allegations about accounts he knew of not being on an early filed financial affidavit would amount to fraud. And it certainly wouldn't excuse him not paying what he was supposed to pay under the terms of the court order. And the motions related, the motion in March 26th related to parenting, he was trying to enforce things that weren't in the marital settlement agreement. There was no court order to make her do the things he wanted her to do. So there's no basis for the court to have granted his motion.
Right. So they weren't going to be successful. It's your opinion they weren't going to be successful.
Yes, that's my opinion.
But would you agree that the things he was putting in there are inflammatory?
I would agree that they were inflammatory.
And they're
They didn't wait to see what the legal effect was because they needed them killed, and they needed them killed in a hurry. Okay? Donna had had enough. When he was feeding enough information, the judge shut it down. Relocation legally was not an option, so therefore this necessitated another plan.
potentially could make the parties or their relatives upset to read those pleadings and those inflammatory accusations.
Right.
Sure, nobody wants to read those allegations, true or not, about themselves in a public record.
You were shown a bunch of binders on a case. That case has nothing to do with this case, right?
No, it was a relocation case.
Right. And that
So what the prosecutor or defense tried to do with this witness is they wanted to bring up another case, mention that and how voluminous it was with how many pleadings and filings and attorney's fees and all that to try to compare it to this case. And it's like, that's not even relevant to anything here. So that was kept out, but the defense tried to do that.
that case, was anybody murdered in that case?
No.
Okay. So if somebody had been murdered in that case, there might have been a lot less paper, right?
Right.
Case
Well,
would have been
great
shorter
point.
if somebody had gotten murdered, wouldn't it, Miss Bailey?
Point, Georgia.
If there wasn't a party, the case would have ended. If that's
And if our case, we hadn't had a murder, we might have a lot more paper in our case, wouldn't we?
no, because the divorce was over in July.
Divorce was over in July, but they kept filing papers, didn't they?
July 13th.
Well, and the case was set for hearing March 15th. May 15th, 2014. So the motion that Ms. Adamson filed in October. And the
What
motion
year?
that Mr. Markel filed in February, and then the motion he filed in March, were all set for hearing May 15th. And then Mr. Markel amped it up again, and on May 5th, he filed the motion that accused Kristen of fraud. So she had to withdraw, so they had to move that motion. So had that not been filed, they would have had a resolution on May 15th.
We don't know that.
Do you see an attorney accusing another attorney of fraud, especially a friend of yours like Kirsten?
How do you know it was going to go on May 15th? Could have gotten continued for any zillion different reasons, couldn't it?
It was set for May 15th, and it was noticed for May 15th.
Set for May 15th, but at the time of Dan Markel's murder, litigation was still ongoing in this case.
Yeah.
Yes? Yes. And even after that was resolved, there was be nothing stopping them from having a bunch of other time sharing issues or whatever come up, and they might have ended up with reams of paper, right?
Overruled, the witness has provided an opinion. The state
Well-
will cross-examine.
I guess my response to that would be, I think it would have been to Wendy's benefit to proceed with those hearings, because nothing makes someone stop filing nonsense pleadings and motions better than having them ordered to pay the other side's attorney's fees. So had they gone to the hearing on May 15th, and had Wendy had been successful, he would have very likely had to pay Wendy's attorney's fees. And I really encourage my clients in these situations to take it to
So you got
hearing.
a father that's frustrated with the way visitation's going on. There's the Holocaust survivors heirloom ring that Wendy won't return. And you have issues involving money that Wendy's not getting her $80,000. So she's angry. All this is pointing to motive to have Dan exterminated. And they're also making Dan look really bad here. They're trying to make Dan look really bad. And obviously he's not there to defend himself. And he's not going to risk his job by making some kind of frivolous motion. So I just don't find this credible at all.
So once the other side gets kind of slapped down, if you will, by the court and made to pay your fees, then they tend to back off.
But
So
that hadn't happened yet.
it had not happened yet.
And we'll never know when that was going to happen because we never got to that point, right?
Clearly.
Because he was murdered.
He had the audacity and gall to point out things the boys said about Donna. And it cost him dearly.
Clearly.
Cost him his life.
May I have a moment to confer, Judge?
A great way to end that. He was murdered. We never would have known how this would have worked out.
Redirect examination.
Briefly, Your Honor.
Right.
Ms. Bailey, you sat through Kristen Adamson's testimony earlier today,
I
correct?
did.
Did that in any way influence your testimony here this morning?
No, there was no new information.
Nothing further.
We already talked about
Will this witness be recalled at any point?
so. Yeah, this witness also, I think she was the one that mentioned something about gibbers and laughed about it. Yeah, there's so much filing here. Yeah, that's hence I can see why he's called gibbers or something along those lines. I remember hearing about. So all right, I want to go to this part then, what we saw about oh, where's the screen there? Sorry, hold on. Let me find this window. All right, this had to do with whether Donna's going to testify, waive the right to remain silent, or whether she wants to exercise her rights to testify in her own defense. part of the Sixth Amendment right to present a defense. So those other two links I was using the trial channel, which is covering a lot of this case. And now I'm going to cover this one here. Whoops. Here we go. Working with a different mouse here tonight, so it's a little bit difficult. And when I post up questions, full screen, that happened before. All right, so check this out. I've never seen anything like this before.
Address before we bring the jurors on. The first, the first concerning the waiver of attorney-client privilege as to the testimony of Mr. Scalzo. I am going to need to place the defendant under oath concerning this. Ms. Adelson, please rise, raise your right hand.
This is outside the presence of the jury.
You swear or affirm the testimony you're about to give will be the truth.
Yes.
You can lower your hand. You understand with your former, or I guess I don't know the relationship exactly, but someone who has previously represented you concerning their testimony today, are you waiving attorney-client privilege concerning what they will testify about?
Yes, I am.
Concerning that, Mr. Zellman, do you wish the court to make any further calls?
Okay.
The waiver is specific as to.
This was the waiver of the attorney-client privilege because they had her attorney from Florida when she initially got arrested, that Descalzo attorney, the female attorney, I forget her first name, but she testified today on behalf of Donna and trying to make it sound like there was issues with the mental health, that Donna was talking about committing suicide and whatnot. So this was something that they needed to get on the record for Descalzo to be able to testify.
The counsel that.
Gosh, he talks so slow.
From Mr. Scalzo.
Well, if you need to discuss this,
Speed it up.
She's waiving, that's fine. I don't believe you.
This defense is so cringy as trial attorneys. It's painful to watch. What's interesting is that, this is the exact same scenario as when Charlie's closing arguments was about to occur. I was able to drive down and watch.
Mrs. Adelson, do you understand the scope of the waiver that you're providing? Do you
Watch the
understand
closings.
The scope of the waiver that you're providing of attorney-client privilege.
This closing should be tomorrow.
What is that scope?
The information that was discussed after my son's trial regarding my travel state of mind.
Is the defense planning to examine this witness on any other topics than what has been identified as the scope of the waiver?
No, Your Honor.
So Descalzo also talked about how
matters are inquired into that exceed the scope at that point.
after Charlie's convicted, there's talk about maybe just take a vacation to get some fresh air.
Before, the state is permitted to cross-examine as to all topics that are inquired to on the defense direct, and also as well matters of impeachment and bias. Does the state need to be heard in any way?
So
As to the other matter concerning whether
they had this attorney testifying that basically it was Harvey's idea to maybe go out of the country. But why would you go to a country that has no extradition with the U.S.? That was key that we heard from Donna's
20 minutes during lunch break.
hot mic. I'm going to speed this up.
To remain silent or whether she wants.
Here we go.
As to a decision. And also as well matters of impeachment and bias. Does the state need to be heard in any way? So at that point, are going to have to send the jury out of the room. As I previously stated before, the state is permitted to cross-examine as to all topics that are inquired to on the defense direct, and also as well matters of impeachment and bias. Does the state need to be heard in any way? As to the other matter concerning whether Mrs. Adelson will testify as a part of the defense case in chief, Mr. Zellman, were you able to speak with her as to a final decision?
I'll allow
I'm sorry.
short answers. We were allowed 20 minutes during the lunch break to speak with Ms. Adelson.
In addition to the time that you had yesterday and other times.
So what the judge saying is your client going to testify or not? We need to know that. And I need to advise her on those options. When are you ready to have that decision made? You don't have any other witnesses to call after the Scalzo. So what's the deal here, counsel? Is Donna going to testify or not testify?
Yes, Your Honor.
If I may, Judge, the issue is that
Well, one moment. Who's handling this matter? We're not tag teaming.
There you go. No tag teaming. Judge won't tolerate that.
Your Honor, what Ms. Fulford and I had discussed was
This is
the factual issues that are concerning our client's decision. And then I was. So,
look at the attorney looking down all the time.
to address was the time that we
Fulford, Jackie Fulford, looking down all the time.
I'm asking that Ms. Fulford be allowed to address the court.
Donna, does she look like she's ready to testify?
the issue that we're facing, Judge, is this was 6 days of testimony from witnesses for the state.
No, what's really going on is your client is absolutely terrified to testify because she knows she's going to be ripped to shreds by the prosecution, and she's going to go up in flames and get exposed for having proven that basically everything the prosecution has been saying for 6 days is indeed the truth, and you have zero defense, because we have not heard any defense from you this entire 6 days of testimony from the prosecution, an actual 7 days now that includes defense testimony, which has nothing to do with helping exonerate your client, because there is no evidence to exonerate her. It's all inculpatory evidence, and Donna will be convicted. I expect it to be tomorrow.
And a great deal of evidence that they have entered. We have discussed with our client, of course, her right to remain silent or whether she wants to testify or not. We have not had an opportunity to go through all of the evidence that's been entered in this case and have a full and frank discussion with her about that evidence. If there are any issues that she thinks need to be addressed for her testimony, whether.
Oh my gosh, this is something you have to be prepared for. This is like these guys have never tried a case before. You have to have your client ready to testify. It's their call, and it's a last minute call, and you build up to that and you prep for that. And now she's saying that they didn't have enough evidence or time to go over the evidence each day. What are you going to do? Sit there and for every hour of testimony, have an hour conversation whether your client wants to take the stand or not? It doesn't work that way. You build up to this. You've been her attorney for almost a year, and you've had this time to go over what her defense is, what would she testify to. So you don't have to worry about all the different evidence against the prosecution, and cover that hour for hour, minute by minute with what was actually brought out in court. So your client should be prepared. So this is almost like ineffective assistance of counsel, because you're saying that we didn't have a chance to effectively discuss it with her. Well, you're basically admitting you're incompetent. That's what was really shocking to see. We were in the courtroom watching this, and we couldn't believe it. We couldn't hear what Donna was saying. We were sitting probably 5-6 benches back behind the prosecution table, but this was the mousy defense lawyers making excuses for why they cannot get Donna to state one way or the other. Does she want to testify or not? Which is it?
Think she needs to testify or not, and what her decision is on that.
When we had the break yesterday at 2:45 in the afternoon, you did not speak with your client concerning whether she wished to testify or review
Absolutely.
the evidence.
Yes, Judge, and that's what I said. We have discussed with her whether she wants to testify or not.
The defendant in every single case, Ms. Fulford, is faced with this moment as the defense.
I've never seen this before.
What are you asking for?
I'm asking for additional time to be able to go through all of the testimony and evidence with our client so that she can make
You should have been doing that.
a fully informed decision as to whether she wants silent or testify in this case.
It's like they're trying to set up ineffective assistance for themselves. Like they have not taken the time to do that. That is your job. You should know that. You have two of you to do that. And you built up to it. It's not just a, well, gosh, it's sorry. It's a few minutes here to testify, Donna. Do you want to testify or not? We haven't talked about it, but no, you as an attorney, you have to have many hours of discussion, go over the questions you'll ask. You'll have some of this scripted out or laid out. So have you not done that? Gone over your questioning even? So it doesn't look like it. It looks like they're completely flat-footed. They weren't ready to go. And Donna, I thought she's all ready to go explain her innocence. And that's what most of us, including myself, thought she was going to testify. Could she still decide to testify tomorrow and reverse her decision overnight? And then the judge reopen the case for the defense? I think that could happen if Donna sleeps on it and decides to testify, but I don't think she's going to decide to testify at all. I think she's terrified. I think she knows that the evidence is overwhelming and she cannot explain it. All these things that she said and done, indicating her hatred and support for the killing of Professor Markell.
Ms. Fulford, concerning that has been provided by the court. If she wishes to testify, we do need to go through the colloquy. If she does not, it's a simple matter. But there has been time pre-trial to prepare for this moment.
Right.
There's been time during trial.
Right.
And specifically, we recessed court early for you to address any issues of witnesses or whether your client would testify.
Yesterday, when you allowed
The
us
judge
to
is livid.
Recess early, Judge, Mr. Zellman and I spent time going through the evidence that was admitted, making sure that
Shame on you.
everything there, because there was some confusion during the trial about things being added and things being removed. So we
What are
wanted
you
to make sure we
talking
understood
about?
completely what there was there. We left here, went straight to the jail, and had the issue with the potential new witness and spoke with our client. But that's not an ample time to discuss with her what is actually coming in the state's case.
Your client is in a no different position than any other defendant.
Everybody
They
else.
have to decide whether they wish to testify or not. I will give you 5 additional minutes to discuss this matter. From there, the defendant is going to have to make a decision whether she is going to testify or exercise her right to remain silent. Please check with the jurors, let them know.
I'm sure the judge never seen anything like this. What an embarrassment for these attorneys. It's like they're not even embarrassed being this unprepared. We're at the end of the trial and they're not ready to go.
Requesting that the court hear Ms.
All right, here we go. Judge is back on record. You gave him 5 minutes. And guess what? Are they going to be ready?
The response from the audience concerning things that are said by the defense.
Talk louder.
And although the proceedings are public, that has not stopped the peanut gallery from their comments and laughter.
Yeah, you guys.
Respectfully requesting that the court allow Ms. Adelson to participate at sidebar as she is entitled, and for the court to address additional issues that are weighing
God.
on Mrs. Adelson's decision.
Oh my gosh.
His approach, we are not going to do
She's
this.
saying we need a sidebar because folks in the peanut gallery are going to be heckling us and laughing at us. And I mean, this is just so unreal to see an attorney actually say this in court and have to have a sidebar to talk about all the issues that the client's facing and making the determination. I don't get it. This is so off the charts. There they are, talking, trying to explain why Donna just can't make a decision. She can't make a decision. Jumping ahead here. All right, so I'm jumping ahead. Come on, Donna, what is it? Are you going to testify in front of these fifth grade knuckle dragger jurors? What do you got to lose? Testify. Charlie testified. He got to speak his mind. At least he got it on the record what his defense theory is. We don't even know what your defense theory is. Now's your chance, because your attorneys haven't presented one of how you're innocent. All right, get your water.
All rise. We're entering the courtroom.
So they're not ready to go yet. That female deputy there with law enforcement, that corporal, she kicked out a number of people today for not even being
Everyone can
loud.
be seated. Members of the jury, I hope you had a restful lunch break. We are going to continue at this point with the defense's case. Please call your next witness.
Before we call our next witness, we laid the foundation through Luis Rivera for Defense Exhibit 50.
This
At this point in time, we'd like to introduce that.
looks like some photos they never
Any
published
objection to
it.
this statement?
At this point in time, the defense would call Marisol Descalzo.
Okay, Descalzo, it's just sort of wasteful testimony. There she is. That's Wendy's, one of her original attorneys that represented her
Please raise your right hand. Do you swear or affirm the testimony you're about to give?
first month after she was arrested. That's not worth listening to. This is pretty much throwaway testimony.
About
Slow questions again by Zellman.
they did. Okay.
She also worried about getting convicted herself.
Here, I'll show the cross. Maybe. How about that?
Say someone.
Says it's
It happened.
Yes, I
Okay.
did.
Okay. And to travel.
Mrs. Adelson was making these serious threats about her life.
Just a moment, Your Honor.
now he's walking over to talk to his co-counsel, as he always does. Decides whether there's any more questions that Fulford thinks he should ask, and in this case, she had none.
Cross-examination.
Well, here's Sarah Dugan.
Now, if someone has a warrant, is it up to the defendant or the suspect, the person who has the warrant, to dictate their terms of surrender?
I don't think so. It's up to the law enforcement.
It's usually up to law enforcement.
Quick
to
answer.
decide how or where to apprehend that person, right?
Yeah.
Is that right?
That's correct.
And that is a courtesy that's sometimes extended in situations where, let's say, someone is not a flight risk, right?
It's in all sorts of situations you can have self-surrender extended to I would
No, you
limit it
can't.
to only
No, you can't.
people that are not a flight risk.
Okay, would that be one situation?
I would assume so, yes.
Okay. And you were told that by Georgia, by Ms. Kappelman, that you wanted to know whether she had a warrant, she could turn herself in. That was some amount of years ago.
It was definitely before Charlie Adelson was convicted. It was on a phone call that I had. I offered it, and as I stated, Georgia Kappelman did not guarantee that.
Okay. But that was before Charlie's trial or verdict.
Correct.
Okay. After the verdict, or I
Think
guess
about that. Even
during the
before,
trial or after the verdict, did you?
even before Charlie was convicted, she's looking at, could I turn myself in rather than being arrested trying to flee the country? So she's already realizing, I think it's an indicator that she's next, Charlie's going down, and she's going to wind up in the same situation.
Disclose to anyone in the state attorney's office that Ms. Adelson was suicidal?
Of course I didn't. No, I had an attorney-client privilege relationship with her, and I don't think that would have been appropriate.
Sure. And why was she suicidal?
Um, because her son had just been convicted, and she was worried he was going to spend the rest of his life in prison.
Was she also worried about getting convicted herself?
I don't believe that that was even crossed her mind. She was only worried about her son.
Okay.
See, again, she can't say anything incriminating against her client unless she has direct, exact knowledge, and then there's no way to not have to answer that question that is incriminating of your client. But there's an effort to always still advocate and minimize the situation to make your client look better.
Are you aware of a text message where she said that she was afraid she was next, but don't worry, she would take care of that?
I'm not. I'm sorry. Was that a text message to me, or?
I don't believe so.
Yeah, I don't have any knowledge of that.
Okay. At the time of, were you present when Dan Rashbaum told her that she may make it to the airport in time, or she may get to the airport and not be able to make it out?
Mr. Rashbaum and I don't believe that was that was a telephone call. I don't believe that that was in person. And I was on a call, and I myself also told Mrs. Adelson that that we did not know whether there was, that we understood there wasn't a warrant, but that didn't mean she couldn't get arrested at the airport.
Okay. When you suggested, I guess, was the suggestion that you said that she take a vacation?
I don't believe I suggested it. I believe that that's something that was being discussed between Mrs. Adelson and her husband, as something that would help her with her mental state.
Okay. So that's something they
Yeah.
suggested, but not you.
Correct. I did not.
So that would help her mental state if she knew she could flee the country and never be prosecuted in America for the death of Professor Markell. Yeah, that would be mentally relieving. Excellent. Excellent. Excellent idea by Harvey.
Just that they take a vacation.
Okay. Did you know at the time that the vacation that they were suggesting, they were considering Vietnam, China, or Korea?
I did not know the location of where they were going,
Okay.
and it was never discussed with me.
So at that time, you didn't have knowledge that they were specifically looking for non-extradition countries?
I did not know one way or another where they would vacation to.
If
That's not a vacation.
Donna Adelson was overheard by law enforcement debating either committing suicide or fleeing to a non-extradition country, do you think that would change law enforcement's stance that she could turn herself in?
Overruled. The witness has opined on this matter.
I'm not law enforcement, so I'm not sure, and I've never been in law enforcement, so I'm not sure.
I can rephrase it.
From your
Would you
experience
expect
with
that to
clients.
change the stance?
If I was law enforcement and I heard a target of investigation discussing a flight,
As her attorney,
okay,
would you expect if she's overheard debating either committing suicide or fleeing to a non-extradition country that she wouldn't be expected to be able to just turn herself in on a warrant again after that?
I don't know. I think it would take, to be honest with you, I'm a criminal defense attorney, so it would be case by case. Probably that would make the bond hearing a little bit more difficult if those
course it
conversations
would.
were overheard.
Bond side, just like that.
But every prosecution is different, and maybe the prosecutor would agree. I don't know.
That's where she's got to minimize, deflect, not make her client look as bad. That's what happens with attorney-client privilege. Always got to be an advocate to your client's benefit. Even though she's no longer representing Donna, she has to advocate in her interest.
Specifically, though, about self-surrender, would you expect that to change law enforcement stance as to self-surrender, not as to a bond?
Again, I think that that's specific to each case, and I don't know exactly what was overheard, so I apologize, but I don't really have a concrete.
Calling this witness is pretty much a
other
waste
than
of time.
What I said before, that it would come up at a bond hearing.
Hold on a minute. Where is?
Redirect examination.
Thank you, Your Honor. Mr. Scalzo, prosecutor asked you
All right. I don't need to
about
go through.
fleeing the jurisdiction.
Let's jump ahead and
And the state also asked you traditionally.
Okay. There's a paper shuffle guy. Where was that piece of paper he's thinking? I knew it was here someplace. What happened to my post-it note? Did you take it, Jackie? How about you? Do you have it over there, Georgia? Sarah, what about you? Where's my sticky note? Donna, have you seen the sticky note? Someone's asking for the sticky note. I can't hear which sticky note. Sticky note, talk about whether you're going to plead guilty or not. How about testifying or not? You going to do that? Where's my sticky note? I don't know where I'm at in this case. Do you? Georgia, am I supposed to rest now? What am I supposed to say at this point in the
Please come up to
trial?
the witness stand.
Here we go. Oh, somebody's walking in. I didn't even notice that. Oh, here's my witness. Oh gosh, I got one more witness. Here we go.
The testimony you're
Hey,
about to give will be the
Jackie, who is this? Who is this gal?
Please speak loudly and clearly.
You take her, Jackie. I don't know who she is.
Good afternoon.
You state your name.
Can you please introduce yourself to the jury?
Yes, my name is Sarah Newhouse, and I am currently the Behavioral Wellness Coordinator for the Police Department. Back in 2014, I was the victim advocate.
You're a victim advocate for the Tallahassee Police Department?
Yes, sir.
Okay. And in your role as a victim advocate, what does that entail when you work for the police department?
Typically, it's following up with victims that are victims of crime, usually persons crimes, homicides, suicides, sexual batteries, domestic violence, things of that nature. And it's providing support, kind of being a middle.
I'm going to jump
person
ahead.
between them.
16th of December.
Yes, I did.
And were you present for the vast majority of her interview with law that interview? And I'm going to show you what is marked for identification purposes.
So they're
as
trying to interview.
1071.
They're trying to introduce the interview that Wendy Adelson had with Detective Isom, where she's calling Donna up, and Donna doesn't sound like she's really shocked at all about it. She sounds like it's scripted. She's not asking any detailed questions about what happened to Dan. She's just talking about, oh, okay, I'll have to come up there, and it's not anything that sounds like it was a shock or anything. But yeah, this was what this person believes. It was a shocking type reaction to Donna. She could hear it through the phone. I guess it was loud enough for her to hear much of it, not all of it. So really odd testimony here, because if you listen to it and the jury listens to it, they didn't publish it, but if the jury listens to it, they're not going to buy it. But you know what? I think this case is so open and shut, slam dunk against the defense that it's not going to matter. They can present all this evidence. I think the jury will come back tomorrow afternoon, 2 to 3 hours. If they stay longer than 3 hours, it's probably because they're laughing and sharing stories of how bizarre this defense case is.
Wendy Adelson called her mother. Do you recall Donna Adelson's reaction to being told that Dan Markell had been shot?
Yes.
Profound reaction.
She sounded shocked, I guess would be the word that you'd say.
Sounded,
And,
not was, sounded.
It appeared that this was the first time she was hearing about it.
Yes.
That's so, prosecution, you should object.
And
That is so speculative. You cannot go into that kind of opinion. Did you form that opinion? Were you thinking that when she said it? Were you skeptical? Why would you remember that?
did she make any statements that you could hear from where you were sitting?
I don't recall if I could hear other than reviewing the video, but it sounded like a normal amount of upset given a crisis situation.
Wow. Okay, she's young, she's inexperienced, she's trying to do the right thing. So I don't fault her for that. The jury can listen to the tape, but she did not sound surprised at all. Those of you following the case and have heard the interview of Wendy, and also when she calls Donna, it sounds scripted, it sounds fake, and no jury would believe it. That's first impression, shocking news, the way Donna reacts. And even the way Wendy's talking to her, it just sounds so so canned.
I don't have an objection. I do want to review it.
Jury,
You can testify, Donna? You're next. They ran out of ammo. You're the last bullet in the firing round. The firing chamber here, Donna. Come on. I'd dread it too if I was you.
you can be seated.
It's a do or die situation,
Anyone
Donna.
needs to stretch their legs or use the restroom, please do it now.
All right, jumping ahead here. Donna, what's the word?
Everyone can be seated. Defense 71 is admitted at this time. You may continue with your examination.
I have no further questions for this witness, Your Honor.
Cross-examination.
All right, let's skip this. It's not worth it.
The jury will have a brief break. They will take.
Okay, brief break. Donna, what's the word?
Please make all necessary redactions and changes at this time.
All right, where's... All right, now the sound went out.
I can tell the court that co-counsel and my client are deep in conversation.
I mean, come on, Judge. This is a big decision to make here, and you're putting us on the spot. We've only known the last 2 days that we had to make this important decision. What to advise Donna to do. She doesn't know what to do, and we don't know what to tell her, Judge. I mean, come on. This is not fair to any three of us. Look at Jackie Fulford's got her mouth covered. She looks sick or something about having to make this decision. I mean, this is like crisis mode here. Disaster management right here. Look at the face of Donna. She's like, what are you going to tell me? Can't you tell me what I'm supposed to do? Well, Donna, you're cooked either way. If you testify, you're going to get smoked and grilled by by Georgia, and it's going to be 8 more hours to get a verdict. Or you can just not testify and get this over with sooner. You decide. I don't know what to tell you.
I'm sorry, I am capable of seeing that, Mr. Sullivan. No narration is needed.
Come over here, Donna. You know, listen. It doesn't make any difference. You know what? Harvey's not giving you any advice. You're on your own. We don't know what to tell you. You tell us. What's the legal advantage of testifying or not testifying?
This is Kappelman. The defense rest is the state intending to place or put on any rebuttal case.
No.
I think not. If they rest without calling any further witnesses,
Mm-hmm.
that could change.
If Donna testifies, we're going to go in for more evidence.
Well, at this point, I do need a decision. Mrs. Adelson, please rise.
Stand up.
You've been
Make a
placed on
decision.
oath earlier this afternoon. Mrs. Adelson, I will advise you concerning your rights. You understand that you have the right to remain silent, and the jury will be instructed that your silence cannot be held against you in determining the merits of this case. Do you understand this?
I do understand.
Do you also understand that you have the right to testify as a witness in your case in chief on your own behalf?
Yes, sir, I understand.
You understand if you do choose to take the witness stand, you will be cross-examined by one of the prosecutors.
Yes, I'm aware of this.
You understand that your credibility will be placed before the jury like any other witness.
Yes, sir, I understand.
Have you been able to discuss, or have you been able to discuss with your attorneys the two rights that the court has placed before you?
Yes, we discussed the rights.
I don't understand it, but
Concerning
they
those
discussed it with
rights
me.
as to whether you will remain silent or whether you will testify. Have you made a decision concerning this matter?
I haven't, I'm not prepared to make that decision.
I'm not prepared.
This decision affects the rest of my life.
Mrs. Adelson, you're in the same.
I don't believe what I'm going to say is credible, Your Honor. So, I mean, you're not giving me a very good option here. You're saying I'm going to be scrutinized like the other witnesses? That's not fair. How am I supposed to get a fair trial if I'm held to the same standards as everybody else?
Position as every other criminal defendant who faces trial.
But I'm not a criminal.
Ultimately, you must decide whether you will testify or whether you will not. I cannot make you testify. Your attorneys cannot make you testify. But ultimately, you must choose whether you will testify
I need more time, Judge.
or not.
I don't have to choose. I was hoping I would have some time to speak to my attorney.
This has already been discussed.
You've been talking to your attorneys for months after months after months after months.
It's your choice.
Huh, she's dreading it, folks. Right there. When I saw her like not wanting to testify, I whispered to Leslie, she's not going to testify. Nobody that's this hesitant to want to get up there on the stand and finally tell the truth, because the government's got nothing but liar after liar after liar on the witness stand. You want your truth spoken. And you know what? She knows her testimony is not truthful. And so I said she's not going to testify. And this is much a surprise to so many people. And including myself, I thought she was going to want to testify because she always is in charge of so many things, controlling other things. But now, when it's her moment to shine, when she can put on the performance of her lifetime, what does she do? She exits the stage left and says, I don't want to take part of this. And you know what? She's got some friends there in the gallery, and she's probably embarrassed that they're going to see how horrible of a witness she is as well. So she doesn't want to put all the chips on the table. What is there to risk if you testify to the truth, Donna? What is the risk?
Judge, since I was handling prior witnesses while Ms. Fulford was speaking with Ms. Adelson, can I have a few minutes, please?
Oh my gosh, you need more time?
What exactly are we going to accomplish that we have not been able to since the trial started, pre-trial, the long recess? Yes.
I mean, the thing that's really troubling me is that Fulford said we didn't have a meaningful discussion with her. That is like per se malpractice. You don't have the opportunity to discuss this with your client ahead of time. You should have been all prepared for her to testify. You talk about the pros and the cons. And a lot of times it is a last minute decision on, hey, now's your time. Do you want to testify or not? Your Honor, we need, 5-10 minutes, or you'll have a lunch break or something like that. And then the client gets up there and tells the judge, Your Honor, I don't want to testify, or they do want to testify. And then they go ahead and testify and get it over with. But this him and hawing and the attorney saying that we haven't really had a meaningful chance to discuss it with her, I've just never heard anything like that. I can't believe an attorney would admit that. Even if they believe that, it's like, if you thought that was happening, then why wouldn't you spend more time? Why didn't you come in weekends, nights, etc., to see your client and get them prepared to testify? So is this something you're trying to try to raise on appeal? Like Donna was never adequately advised that she had a right to testify. So by her not testifying, this does create more of an appellate issue, I would say, by her counsel admitting that they've not had meaningful discussions with her.
Today, or even the lunch break today.
That's what I'm trying to determine, Your Honor.
I will give you exactly 5 additional minutes.
Another 5 minutes.
Mrs. Adelson has to make a decision whether she will testify.
Look at her head down. What's going on with Jackie Fulford?
Thank you, Your Honor.
Look at her.
If
Get your
anyone in the
chin up,
gallery needs
Jackie.
to
What's
use the
going on?
restroom or stretch your legs, this is your opportunity at this point.
So we're sitting there wondering what the heck is going on with Donna. In charge Donna dictating to her attorneys how to try this case, and now all of a sudden she's got to take the stage, and she can't even make a decision on that yet. So let's jump ahead. After they've had some more opportunity for meaningful discussion.
Mrs. Adelson, the extra time that you have been provided, that has come to a conclusion.
He's really mad at the attorneys more than he is Donna. They should not be put up with this kind of.
We are not finished with the colloquy quite yet. I am not talking for the sake of talking.
The lawyers are
We have to
talking
move
among
on
themselves,
to
ignoring the judge.
We do need to move on.
See, they're all huddled up there.
Mrs. Adelson, the question remains, as it relates to your right to remain silent and your right to testify, what is your decision concerning these two rights?
Look at her flutter eyes. It's like something you got to live with the rest of your life, Donna, like you said. At this time.
As I've previously stated,
See, she couched it.
jurors will be instructed that your silence cannot be held against you in any way. We will bring the jurors back out. The defense will rest its case on the record. Ms. Kappelman, you indicated the state will not have rebuttal.
Did say that, Judge. May I have a moment to confer with co-counsel?
You know, if the judge says at this time, if the defendant says this time, I don't want to wait. Tomorrow morning, if I was a judge, I'd probably say, are you still standing by your decision not to testify? Just to try to help avoid this being an appellate issue. Because right now, you got lawyers to the right of her that really are clueless on how to handle the situation. It's like they're brand new lawyers. They don't know how to prep a client to determine whether they need to testify or not. So what happened here the rest of the afternoon? They call the jury back in. They had some minor stipulation thing they want to read to the jurors.
Stipulated or agreed that Patricia Bird was never listed on the defense witness lists.
The defense wanted stipulation that that inmate Patricia Bird was on the witness list. They just want to stipulate to that.
As to that, prepare the stipulation in writing. It needs to be signed. The preliminary copy of the jury instructions was sent to everyone, right?
So now they're going over jury instructions.
To the room. The defense will rest. We will send them home for the evening. I will give you a few minutes to look through the instructions. We'll go through the charge conference. And then tomorrow we will move into instructions and closings.
Your Honor, the council have a moment to confer concerning whether or not we are going to rest at this point.
Do you have another witness to call?
That's what we need to discuss, Your Honor.
Boy.
Done a lot of conferring. Please quickly
Be decisive,
decision.
counsel.
There is another witness, in fact, for the defense.
Pretty much the consensus in the gallery and also in the media room is that these attorneys are pretty much cringy and embarrassing to watch. This is something you decide last night and early this morning. You don't decide that here in the last minute in court. I just never seen anything like this. They're going to bring the jury back in. They decide to rest.
Qualified or hearsay exceptions. States indicated that she's
So what they want to do here now is they're wanting to bring the rest of Donna's diary entries for the years that they brought out the calendar, indicating that they had Professor Markel's license plate number in Donna's planner book for 2014, the year he was murdered. So they want to have all the entries brought in. And so there's this do loop about, well, why is the rest of those relevant and all that kind of stuff. The judge has not made a determination on that as of yet. But I don't think those are going to come in. The defense was saying for rule of completeness, we want to introduce all those, but if they don't have anything to do with anything other than the fact that I think they're trying to make her look like a busy grandmother and make them feel guilty about sending her down the river in prison. So that's the only relevancy they have, trying to making some kind of emotional connection by entering the rest of those diary or calendar entries into evidence. That's how little evidence they got to try to rebut the overwhelming evidence against Donna Adelson there.
Zellman, concerning the items, we do need to move on, so a ruling can be made.
And the defenses can't get their A game going. Come on.
Client, as well as the 2023 calendar for my client, under the rule of completeness, we are asking that the court admit 14 calendar as well as the 2023 calendar. That is.
He talks so softly in the room. We're, like, say, 5-6 rows back on the prosecution side. You can barely hear what they're saying. As a trial attorney, you need to have a voice that carries throughout the room. You shouldn't have to need a mic. So this super soft spoken advocacy is just really hard to literally listen to audibly. Besides the lack of preparation, frustrations that the audience and jury must feel on this. Look there. Okay. Checking the box. Shuffling papers. Even Jackie looks like, what the heck are you doing? Donna's like, I'm cooked. You guys are terrible. I paid 1.5 million for this slop. Shit. I'm going down because of you.
State's objection is hearsay, Your Honor, the portions that were admitted by the state for very specific purposes.
I mean, one of her defenses on appeal could be I couldn't decide to testify because they couldn't advise me on the pros and cons of testifying, and they're so unprepared and ill-prepared that I didn't trust them even no matter what they told me at this point.
The rest of this item is not needed to add context to those individual entries. It's a day calendar. It's not a narrative. I don't think there's any argument for completeness. There's tons of self-serving hearsay, and there's state objects.
You know, I think her planner is probably going to be incriminating because it's going to show that she was obsessed with the sunshines.
Your Honor, with respect to the 2023 calendar, the state introduced a few.
All right, I'm going to jump ahead. This is ridiculous.
Whether or not she was planning to sell something in January of 2023, what witness testified concerning that?
So basically, the judge is saying, what is this? How is this relevant? You have not laid any foundation for how any of these other calendar entries are relevant. Anyway, let's just jump ahead here.
Seeking to admit are the pages from the 2023 calendar.
He's still talking about it. There he is conferring some more.
The argument for the 2014 calendar would be the same under the rule of completeness.
Okay.
Object.
So that ruling's under advisement with the court.
Yeah. Jurors are fine to come in.
Look at how lost they look. That whole defense table is just like like they pulled people off the street and said, "Hey, go act like lawyers in this case." Donna's looking at them, but they're not looking at her. They're not taking any notes. We noticed that this afternoon. The jurors pretty much
Everyone can be seated.
realize the defense is just
Defense may
fumbling,
call the
stumbling.
next witness.
All right, at this point in time, the defense rests.
At this point in
This will be
time,
heard with the
see,
defense
so as he qualifies that by tomorrow will be a different point in time where he has a different statement to make. It's like, look how indecisive he looks right there. He looks scared. Look at the face Jackie Fulford has. Donna, she's just looking down, wants to bury her head, thinking, well, what a clown show this $1.5 million defense team has turned out to be.
arrested. Is the state planning to recall or call any rebuttal witnesses?
No, Your Honor.
With both the state and defense having rested their cases at this time, we are going to go into recess for the evening. I have some matters that I need to discuss with the parties. And from there, tomorrow, you will receive your instruction on the law and the closing arguments will take place.
Closing arguments tomorrow.
Once again, do not discuss this case with each other or any other person. Do not seek out any additional or outside information from what has been presented to you in this courtroom. Please report tomorrow at 8:45 and we will get started at 9 o'clock, or at least attempt to. Have a good
Yeah,
evening.
attempt to. Yeah, maybe Donna's going to decide to testify. And so, yeah, everything's up in the air when you got these non-committal lawyers. And Donna, look at Donna. She's not happy with her lawyers. The judge shaking his head like, what the heck did I just witness? What an embarrassment.
Everyone can be seated.
All right, so then they're going to go over
Please
jury
open your copies of
instructions.
jury instructions.
So at this point, we decided to go ahead, after a few minutes, to decide a line and paragraph. Here we go. Maybe it's coming back now. No. I can see myself in a small box in the corner, but it will not present full screen. There we go. Delayed connection there. So if I show questions, they do not allow the screen to remain. They basically make the screen go blank. So Katrina Dancer, you're asking about super chats, what I consider accepting for charity. You gave your birthday money to Animal Rescue this year. I mean, give it to some other charity or something like that. The thing is, folks, if you give me super chats, and if I give it to somebody else, I'm having to pay income tax on that. So, I mean, I'd just rather have you give that directly to a charity of your choice. If there's a good cause, something like Karen Reed's defense, then I will say something like that to direct any money to instead of me. But super chats, we don't need the money, and it's a much appreciated gesture on your part. I appreciate justice. Karen, Roman, you're thinking it's a sham to cause an appeal. Yeah, I mean, it's, I guess I didn't disappear that time. All right. Yeah, I don't think the attorneys are intentionally trying to throw this case. I just think they're just all on so many levels. Yes, we're in Tallahassee. It's after midnight, so I'm going to be signing off here. Yeah, I think the verdict will come back in 2 to 3 hours. If it takes longer than 2 to 3 hours, like closer to the end of the day, maybe they just want to chuckle and laugh about all the crazy stuff they've heard on this case. So Nerd, you're saying, doesn't the defense point basically work against them? If Danny Markel was a terrible guy, that just increases their motive. The worse he seems, the more likely DA would have wanted him gone, right? Yeah, that's what I basically was saying earlier. It's like they're making him out to be a bad guy, more of a reason to get him whacked. So that's what I'm saying. You don't trash a victim like that. We didn't get all the trashing, but it's there if you guys want to go back and look at it on the Trial Channel or Tallahassee Democrat. I think she must have paid 1.5 million combined with these two attorneys. I don't have any personal firsthand knowledge of that, of course. Sophia, yeah, Jackie's completely checked out. That's what it looks like. They both have. It's sort of like she let her foot off the gas and is not really helping him anymore. She's taking less witnesses. So anyway, we got to get up early for court. The house is going to be packed, people crammed in there, and we want to make sure we get there early enough that we don't have to watch it from outside the courtroom. So go ahead and sign off now. Thanks for supporting Justice for Markel's, and we'll be back on tomorrow. And let's see if once there's a verdict. Actually, I may come on if there's after closing arguments. I may come on at the lunch period and give some quick summation. And then after the verdict, we'll come on at some point tomorrow night. So I expect good things happen for justice for the Markels tomorrow. And guess what's going to happen next is that more and more of an outcry there will be for the prosecution to go after the main benefactor of this murder. So more to follow. Stay tuned, and we'll talk to you tomorrow. Take care. Be safe.